I'm a person with a disability. Um, this eviction is a retaliation. There was a complaint filed with Fair Housing, and the complaint was finalized up like the end of October. After the end of October, that's when all of this occurred. Sir, I've never changed the locks. They changed the locks for me when my daughter moved out. So as far as the lease violation, um, I have never been out of control. I've never hurt any staff. I've never caused any injury to anybody in my complex or in the leasing office. So, like I said, this is a retaliation. I'm a person with a disability, and they're just Kim is just going forward on her own behalf, huh? And I think it's colored too, but that's all I have to say, sir.
All right. So we're
Do
going
my
to begin
witness need
then
to?
with Mr. Vasquez. You may call your first witness.
Your Honor, I'll give a rundown of the specifics of the case before calling on Ms. Duque to testify.
That's fine.
Oh yeah.
All right. Yes, Judge. On January 27th of last year, Ms. Wheeler entered the leasing office and became agitated with staff. Judge, this was simply because they were too busy assisting with somebody else and could not immediately attend to her. Uh, in response, she raised her voice, followed staff members through the office, and refused to de-escalate despite being politely asked to do so. Um, Ms. Duque attempted to disengage from the situation by retreating to a nearby office space. However, Ms. Wheeler blocked the doorway to that office space and prevented Ms. Duque from entering. And in the process, she intentionally pressed the door against Ms. Duque's foot. Ms. Duque was injured as a result, and her injury, she lost an entire toenail because of that. When Miss Duque attempted to move away again and go to another nearby office space, Miss Wheeler blocked her a second time and again pressed the door against her foot. Whenever staff was able to successfully get away from Miss Wheeler, Miss Wheeler then screamed and banged on the door, which prompted staff to call APD. As a result of this incident, Judge APD issued a criminal trespass warning, barring Miss Wheeler from entering the leasing office, and that was attached to our petition as an exhibit, Judge. However, Judge, despite receiving this criminal trespass warning, Miss Wheeler continued to enter the leasing office regularly and aggressively confronted staff. Judge, this is memorialized in a formal lease violation that was issued to Miss Wheeler on February 28th of last year. And Judge, that too was also attached to our petition. Judge, we wish to stop there, but beginning March of 2025, Miss Wheeler was observed taking photographs of Miss Duque through the leasing office window. For context, Judge, Miss Duque was inside the leasing office in her own separate office, and Miss Wheeler was outside the building, went to that office window, and was taking pictures of her. Additionally, Judge, Miss Duque is also a resident, and Miss Wheeler has also been observed taking photographs and videos of her children. Judge, as you can,
Kids. I don't even know my kids.
Your Honor,
I don't
may I
even
ask
know
Miss
no
Wheeler
kids.
to mute her microphone unless she's going to give a formal objection?
Yes. So, Ms. Wheeler, if you don't mind, if you're going to object, then make sure that your mic is not muted, but otherwise keep it muted if you're going to be speaking to your daughter, because it's a little disruptive. I can't hear what he's saying, okay? All right,
Thank you,
thank you
Judge.
very much.
And Judge, as you can imagine, Miss Wheeler taking photographs, not just Miss Duque, but her children, has caused Miss Duque a great amount of fear for not just her safety, but her children's safety as well. Judge, on December 8th, management discovered that Miss Wheeler changed the locks on her unit without authorization in violation of paragraph 20.2 of the lease. And on December 9th, while Ms. Duque and a staff member were attempting to issue Ms. Wheeler a notice to vacate, Ms. Wheeler again became argumentative and confrontational with them. Ms. Wheeler accused Ms. Duque of slamming the door on her finger, and Ms. Wheeler later displayed what she claimed was a bloody finger. However, Judge, it was red marker, as it was not blood. It looked nothing like blood, and there was no source of bleeding. Shortly thereafter, Judge, Ms. Wheeler's daughter, who's not a resident or not on the lease at all, entered the leasing office and engaged in threatening behavior towards staff, which required the police to be called again. Due to Ms. Wheeler's continued interference with management operations and disruptive conduct, she was also issued additional lease violations on December 10th and December 15th, which were again attached to um, our petition. Judge, as we discussed, notice to vacate was delivered on December 9th. Given this was pre-SB 38, it was a 30-day notice that was provided, and the property is a CARES Act property.
When
Judge,
was the notice provided?
it was on December 9th.
Okay, and when was this, and how was it provided?
Judge, it was posted on the exterior of the unit's main entry door and mailed out that same day.
All right, and then how many days or what day did it actually get filed, the case?
It was January 14th.
All right. All right.
And
I'm going to allow Ms. Wheeler to ask any questions of you since you gave that statement.
all right, Judge. We're also requesting attorney's fees as well, if you would like me to testify to that or reserve that.
Yes.
Just for the foregoing, we're requesting $2,000 in attorney's fees. Would you like me to testify to?
Yes.
Judge, I'm Stephen Vasquez. I am a May 2023 graduate of St. Mary's University School of Law. I've been licensed in good standing with the State Bar of Texas since October 2023. Sanika Reddy, she's also an attorney at our firm. She was actually the originating attorney of this case. She's based in India, so she was not present here for today, but she initiated the case. And so combined, we have spent a total of 9.1 hours on this case for a total of $3,235. Of that, we were requesting $2,000 in attorney's fees. And in your honor, it is my position that all fees occurred in this case by our client have been reasonable and necessary.
All right, tell me real quick, what is the rent?
The rent,
Monthly rent.
is $1,455. Or sorry, $1,455. That's correct.
Is she in arrears at all or is she current?
She is current. I'm not sure about February though.
Okay. All right. And are there any government subsidies associated with this lease?
No, Judge.
All right, Ms. Wheeler, I'm going to give you an opportunity to state your case in a moment, okay? Do you have any questions for Mr. Vasquez regarding the statements that he made?
My first question is, you said that the violence in the office occurred in January.
Correct.
Um, Kim assaulted me.
Okay, ma'am. Ma'am, hold on.
I had gone across the street.
Miss Wheeler.
I had gone.
Miss Wheeler.
Uh-huh.
Right now, it's just if you had any questions about what he talked about, right? If you want to give your statement, I'll let you do that in a moment about, your allegation that she attacked you. Okay. If she gets called as a witness, then you can ask her about that also. Okay. But now I only want you to ask questions of Mr. Vasquez about what he talked about.
Why am I, Mr. Vasquez, required to pay legal fees when it's a low income apartment?
Because you agreed to pay the attorney's fees incurred pursuant to paragraph 23.
I didn't agree. I didn't agree.
Uh,
I didn't agree to anything. I haven't
Ma'am.
spoken with you. So how would I have
Miss
agreed?
Miss Wheeler. All right. You get to ask a question, right? You may or may not like the answer. Okay. So you just have to let him answer it. And then it's up to him to provide evidence, right?
Okay.
Based on your questions. Okay.
Okay.
All right.
Now, how am I required to pay legal fee? And there's been no contact between me and you.
Because pursuant to paragraph 23.5 of the lease, which was attached as an exhibit to our petition, you agreed to pay all reasonable and necessary attorney's fees in the event that your landlord evicts you.
Okay.
All right, Ms. Wheeler, do you have any other questions?
Okay. That's in the lease, correct? That's in the lease, correct?
Under paragraph 23.5, correct.
Okay.
And Judge, if I also may add,
Um,
Well, hold on just a moment. Any other questions, Ms. Wheeler?
no.
No. All right. Mr. Vasquez, you said you wanted to add something.
Yes, Judge. With regards to the claim that Ms. Wheeler made about retaliation, she did file a fair housing complaint in March of last year, in which that delayed our process in filing an eviction out of a retaliation claim. However, the city of Austin dismissed the claim, finding no reasonable cause in October. That's what prompted us to continue with this eviction.
All right. So there's a child somewhere. I'm hearing it. I mean, I see all of you are on mute, so I don't know where the child sound is coming from. Oh, okay, I see. So I heard the sound from Miss Wheeler's house prior to being muted. Okay, so if you can, Miss Wheeler, if there's any way to put the child in another room, if your daughter can go until you need her to come in, that'd be great. Thank you. All right, Mr. Vasquez, do you have any witnesses you wish to call?
Yes, Your Honor. We'll call on Kimberly Duque.
All right, is it Ms. Duque? Ms. Duque, how do you pronounce your name?
Duque.
Duque, okay. All right, you've already been sworn in. You may proceed, Mr. Vasquez.
Please state your name.
Kimberly Duque.
And I need you to speak up, please.
Kimberly Duque.
All right.
And where do you work?
I'm an assistant manager at Goodnight Commons.
Okay. And are you familiar with the tenancy of the defendant?
Yes.
On January 27th of last year, did Miss Wheeler enter the leasing office?
Yes, she did.
And did she become upset and raise her voice?
Yes.
Was this because you couldn't immediately attend to her?
Yes.
Did she then follow you throughout the office?
Yes, she did.
Did you try to disengage by going to a safe spot?
Yes.
Did she then block your access to that?
Yes.
Did she press the door against your foot?
Yes, she did.
Did this cause you pain?
Yes, it did.
And were you injured?
Yes, I was.
How?
My toenail.
So Ms.
It fell
Duque,
off.
I can't hear you. And I'll tell you right offhand, I have a hearing impairment, so I need you to speak up. And speak clearly into the microphone there. We have the air conditioning system here that's gone off, and so that's a humming sound that I'm getting along with your voice. So I need you to speak clearly, okay?
Okay, Honor.
So Miss Wheeler caused your toenail to completely fall off.
Yes.
Did she then block your access a second time?
Yes, she did.
Did she press the door against your foot again?
Yes, she did.
And during this incident, were you scared?
I was. I was.
And were you afraid that Miss Wheeler was going to hurt you further?
Yes.
And as a result of this incident, did police issue Miss Wheeler a criminal trespass warning?
Yes, they did.
And after receiving that warning, has she since entered the leasing office?
She did.
And beginning March 2025, was Miss Wheeler taking photographs of you while you were inside your office?
Yes.
And do you live on site?
I do live on site.
Have you also seen Miss Wheeler taking photos or videos of your children?
Yes.
And does this cause you to have fear for your children's safety?
Yes, it does.
On December 9th, did you issue Miss Wheeler a notice to vacate?
Yes, I did.
And did Miss Wheeler step out of her unit while you were attempting to issue the notice?
She did.
Did she become argumentative?
Yes, she did.
Did she accuse you of slamming the door on her finger?
Yes, she did.
Is that accusation true?
No, it's not true.
Did she later claim that her finger was bleeding?
What was the question?
Did she later claim that her finger was bleeding?
Yes.
Was her finger bleeding?
No.
What was on her finger?
Marker.
Did Miss Wheeler's daughter thereafter enter the leasing office?
Yes, she did.
Was she being abrasive and aggressive towards staff?
Yes, she was.
And did this prompt Miss Wheeler to be issued, or this prompt you guys to issue Miss Wheeler more leasing violations?
Correct.
Because of Miss Wheeler's repeated pattern of conduct, do you no longer feel safe at work?
I don't feel safe.
And knowing that Miss Wheeler is on property, do you no longer feel safe in your own home?
No, I don't feel safe.
I'll pass the witness, Judge.
All right, Miss Wheeler, do you have any questions of the witness?
Yes, I do.
All right, you may proceed, ma'am.
Kim, why was I coming in the office? Why was I coming into the office?
Objection calls for speculation.
Overruled. She's just simply asking her, well, no, yeah, I guess right. Sustained. Miss Wheeler, you can ask a leading question. And let me go back a sec, just so we're clear, Mr. Vasquez, every question that you asked was leading. And your witness didn't give any testimony at all whatsoever. All she said was yes and no. So I'm just going to let you know that up front. I am going to allow some leeway because I can in this court, right? And so that means that leading questions from Mr. Vasquez generally are going to be admissible and allowable, but the same thing for Ms. Wheeler, I'm going to tend to allow her some leeway as well. Keep in mind, Ms. Wheeler, we don't want her to assume why it was that you came into the office, right? So you can ask her a question about, and kind of just, if you think she knows why, you can ask her, didn't we have this conversation? And she can answer yes or no as to why you came in the office. Does that make sense?
Yes.
Okay, so if you want to rephrase your question, but do it in such a way that she doesn't have to guess at to what you're
Where's a
thinking.
yes or no answer?
You can ask a yes or no.
Okay.
Yes. Or questions, I should say.
Okay. Miss Kim, was your foot injured or was my foot injured with the closing of the door?
Objection, compound question.
All right, I'm going to allow it. Ms. Duke, if you just answer if your foot was injured.
Yes, my foot was injured.
And did you see if Miss Wheeler's foot was also injured?
No, her foot was not injured.
Okay, Miss Wheeler, you may
I
proceed.
never pushed on
Okay.
her.
Was my purpose for coming in the office because you asked me to come back when you were less busy?
Can you repeat that again, please?
Was my purpose for coming in the office, in which I never came in the office, I stood in the hallway, but was my purpose for visiting the office that day was it because you asked me to come back when you were less busy?
The first time, no, but the second time, yes.
It was only one time. I only came there one time. The
Objection.
first time I came back,
All right.
the
So Ms. Wheeler,
first
hold on.
time.
Ms. Wheeler, hold on. There's been an objection. So
Okay.
again, you have an opportunity to ask her questions, right? You're free to ask any questions you want, but you cannot argue with her responses. You may or may not agree with
Okay.
those responses, right? But that's what they are. You can provide testimony
Okay.
later, and I'll give you an opportunity to do that, that I would have to then take your testimony, weigh it compared to hers, compare the two to make a determination of which one carries more weight. Does that make sense?
Yes.
Okay, but you don't get to
Okay.
argue with her responses. You don't get to make your own commentary on her responses, okay?
Okay.
All right.
The
Go ahead.
first time, as you say, I came to the office. What did I come into the office for? What did I come for?
You asked for help.
Help with what?
You wanted fax papers.
I wanted what? I didn't hear you.
You wanted faxed papers.
And what was your response?
I told you that I was busy if you could come back later.
Is that what happened?
Objection asked and answered. She testified. She's under oath, Judge. She testified that's what happened.
Okay, so I'm just going to clarify. I'm going to overrule that. I think what she's asking is when you asked her to come back later, did she come back later?
Yes.
She did come back later.
All right.
Okay. Um, and when I came back later, you finished the last person that you were waiting with, that you had in your office.
So I didn't hear any of that because it was cutting in and out. Are you
Okay.
asking her a question?
Yes.
Okay, ask the
When
question.
I came back, was the last person that was in the lobby in your office?
There was people already in my office.
Okay. When those people left, was it someone other than myself sitting in the lobby?
They never left.
They left. Oh, I'm sorry. What about the couple, the Caucasian young couple that came after I was sitting there? Did you not take them into your office and just overlook me?
I don't know who you're speaking of. I don't know Caucasian. I don't know their ethnicity, and I don't guess what their ethnicity is either.
Was there someone in the lobby?
There was multiple people in the lobby with scheduled appointments. Yes.
Ms. Wheeler, you're muted again. If you can unmute yourself. If you pass your mouse or your cursor over the bottom, there you go.
Can you hear me now?
Yes, ma'am.
Okay. Was there not, besides myself, a couple in the lobby, a Caucasian young couple in the lobby, that you saw me sitting there by myself, but you proceeded to wait on them prior to waiting
Objection
on me?
argumentative.
Overruled. I'll let her just ask the question, then I'll chime in a moment.
Thank you, Judge.
Did you not wait on the other couple prior to me?
I don't recall. Like I said, there was numerous people with appointments.
So Ms. Wheeler, let me it's not my intent to help you in your case, but let me give you some information that is going to be useful to you with respect to your case, so you understand. In a forcible entry and detainer, there are no counterclaims that are allowed in these kinds of cases, okay? That also means is that the only defenses are related specifically to the allegations that they're bringing forth. So if it's unpaid rent, and that's the only allegation they're making, you can only ask questions or provide evidence with respect to having paid the rent or not paid the rent. In this case, their argument is about the lease violations, okay? So
Okay.
you can ask questions about the lease violations. Now, if you have a claim, right, because they treated you in a manner that was inconsistent with state law, federal law, or the Constitution, you can always file a lawsuit against them for that. But in this
Okay.
case, it's not a defense. It will not help you
Okay.
one bit. Okay. So feel free to file that lawsuit if you like. But unfortunately, here, we can talk about it all day long, but it's not going to carry any weight. Okay.
Miss Kim, when did you realize that the locks were changed?
It was December 8th.
And what was you in the process of doing?
Judge, I'll object to relevance.
Okay. Ms. Wheeler, do you want to maybe explain your question or rephrase your question?
On December the 8th, when you realized the locks were changed, what was your reasoning for entering my unit?
A notice was gonna be put at your door.
I didn't hear. I didn't hear you.
There was a notice that was supposed to be put in your door.
On my door or in my door?
In your door, on the back of your door, inside.
Oh, what was that notice for?
Judge, I'll object to relevance.
Overruled. She was asking about the notice that was placed inside the door, and she's asking what was the basis of the notice. So I'm going to allow her to answer it. And Ms. Duco, you're on mute. Okay, there
It
you
was
go.
a notice to vacate.
Due to what grounds?
The notice to vacate was for your behavior and how you had been harassing us at the office.
But the notice that was received was for the lock, for the locks being changed. I never received a notice for my, as you say, my actions coming into the office. Yes or no?
In that particular day, we couldn't issue the notice to vacate because the door, we couldn't get into to put it inside the door.
Well, what was the first notice of the lock violation?
I didn't understand your question.
What was the first notice of the lock violation?
For changing
So,
your
Ms.
locks.
Duque, before you answer, just to be clear, I want the responses to come from you. I don't want you to speak to the other person to find out to confer with her on what the responses are. I need you to respond to these questions, okay?
Understand, Your Honor, I just didn't understand the question. We issued a lease violation notice for the changed locks on the 9th, but on the 8th, I initially, the notice that was supposed to be in her unit was the notice to vacate, but that wasn't delivered because the door was, we couldn't get into the door. I was just confused, I'm sorry.
That's okay.
So you're saying on the 8th, you were issuing me a notice violation. And then on the 9th was when you determined that the lock had been changed. Am I clear? Is that your testimony?
No, Miss Sandra, I didn't say that. On the 8th, I tried to issue a notice to vacate, but your locks were changed. On the 9th, I sent out a notice to vacate, and then additionally, I sent out the lease violation for changing your locks.
Okay.
You're saying that you sent out 2 separate lease violation notices.
The first one was a notice to vacate, and then the other one was the lease violations for changing the locks.
Okay, thank you. Do you have any more questions, Ms. Wheeler?
Yes. Why did the notice on the 8th said the violations of the lock? And then the 9th
Well, hold on, let her answer that
was,
first.
oh, okay.
The notice is dated on the 9th, but if you read on the bottom, it says on December 8th, management attempted to deliver legal required notice to vacate.
It's the opposite.
Objection, argumentative. It just wasn't a question.
Sustained. You'll be able to provide testimony, Ms. Wheeler, here in a moment, and you can give your version, okay?
Okay.
Any other questions?
I'm done with the witness, sir.
All right, Mr. Vasquez, do you have any follow-up questions?
No.
Yes, real quick. Kimberly, the notice to vacate was delivered to the lease premises on December 9th, correct?
Correct.
And in that notice, does it advise Ms. Duque that she is in default for improper conduct?
Correct.
I'll pass the witness, Judge.
All right, Ms. Wheeler, anything else from Ms. Duque?
Not at this time.
All right, Mr. Vasquez, you may ask or call your next witness.
No further witnesses, Judge.
All right. Okay, Ms. Wheeler, you now have an opportunity to give your own testimony to explain what went on.
Okay. Thank you. In January, well, when I went into the office, I think it was in January, I had gone across the street to get my my Metro Access application faxed because I looked in the window and she had some people at her desk and she had some people waiting out in the lobby. So I went on across the street to the apartments across the street to try to obtain my Metro Access application, my renewal application faxed to them. They tried to fax it 6 times with no response to the fax machine. So on my way coming back home, I asked Kim if she would fax it for me. Her response was to come back later when I'm less busy. I said, okay. I went upstairs. I waited an hour. And so I went back downstairs. I sit in the lobby. She had the looked like the lobby was clear. There was nobody in the lobby. But the last people that were out in the lobby were sitting at her desk. So I waited until she finished with them. And when she walked them to the door, to the door to leave out of the office, I said, Kim, can you fax my papers? She said, faxing your papers is a privilege, and I don't have to do it. So I said, well, you told me to come back when you're less busy, and I'm coming back when you're less busy. And so she said, whatever. And she began to, the door is a glass door. She stepped in because I never entered the office. She stepped behind the door. And as I was talking to her through the door, she shut the door and smashed my toe. The door opens, I guess you would say, in or out. So there's no way for her toe to get smashed if the door opens in or out. Now, if it was the door was out or in, I could say yes, her toe got smashed. But the door was in or out. As she began to push the door up to close it, that's when she caught my foot through my house shoe. And I went to the doctor. I've got a medical statement. The toe bled. The toenail never came off, but it was just discolored around the edge.
Are you talking about your toenail at this point?
Yes,
Okay.
but and I've got medical documentation showing where I went to the doctor, because that day it was close to the time for me to go to work, for me to catch my Metro Access. And so I wore a house shoe that day to work. But the next day was when my daughter took me to the doctor because the toe was too swollen to put in a shoe. So that was the January. Now when I was getting dressed, the police knocked on my door. And so he said, Miss Wheeler, he said, a
Objection, hearsay.
trespassing order was.
Okay, hold on, Ms. Wheeler. Any statements made by a party that is not here today to testify to them generally is not admitted into evidence. Do you understand that?
Okay, yes.
So in other words, you have to
Well,
be firsthand knowledge. You can't tell me what someone else said.
okay. The police knocked on the door to tell me there was, wait.
Objection, hearsay.
The police knocked on the door. And
Okay.
and at that point, at that point, I wasn't to go back in the office.
So he gave you
I haven't gone
the
back.
trespass notice, right?
Yes.
That's when that was spoken about previously. Okay. You can
Yes.
tell me what's on that because they've submitted that information. So is there anything on that criminal trespass notice that you want to talk about here?
I've never received it. I've never received
Never
anything.
hand delivered it to you?
A trespass notice. I was just asked not to come back in the office.
But he didn't give you a piece of paper.
He never gave me a piece of paper. No, sir.
Okay.
Since then, my biggest concern was how was I to pay rent. So I called the area manager, and she arranged for Becca to be the point of contact if I needed anything done. So I would meet Becca either outside in the lobby, or either sometimes I would go down to the other property where she worked to take my rent. I haven't since then been back in the office at all, sir. Now, as far as Kim's kids, I don't even know Kim's kids. If they were to stand right in front of me, I could tell you, oh, that's Kim's kids. So for her to say that I've taken pictures or whatever of her kids, I don't know her kids. I do not. Let me think. What else did she say? Um, as far as the December the 8th, nobody knocked on the door. I was homesick. Nobody knocked on the door. I heard some noise like somebody was messing with the door, like and so now nobody knocked on the door and announced themselves as doing nothing to the door. So I opened the door. So it was Kim standing at the door, and it was Juan, the maintenance guy with a camera, standing outside the door. Kim was at the door. He was standing outside, like a distance away. So I opened the door and I asked her, I said, "What are you doing?" So she says, "You will see in just a minute." I said, "Well, I got the door open, whatever that is that you're putting the tape on, if you could reach it to me." Ah, I've been instructed to tape it on the door. Just close the door. So the door was all the way open at first, so I closed it halfway. And so she continued to stand there. She said, "Close the door, close the door, close the door." So I closed it a crack with my finger stuck between the door. You know how you do your finger like this and hold the door. And so she reached down and grabbed the knob and slammed my finger up on the door. I hollered behind the door, "You smashed my finger. You smashed my finger." I went in the hallway to show the cameraman, the one, that my finger was injured. She got it taped on the door, and she took her little picture with her like this, pointing to the notice on the door. And then they walked off. She never addressed my finger or nothing. So I went downstairs to I could look out the window. I went to the second floor and I saw that Becker, the manager, was on the premises. So I had a seat in the lobby so I could show her my finger. Becca came out of the restroom and she said, "Miss Wheeler, we're not gonna deal with that today." She said, "That's nothing but red marker on my pitch. That's nothing but red marker on your finger." I said, "My finger is bleeding." And I took, there was a piece of tissue that I had put over it to try to, stop it from bleeding. And I said, "Here's the blood on the tissue. How is it marker?" So she just kept on walking. She never stopped. She just kept on walking. So at that time, my neighbor, which lives um, 13, 17, she was coming in. And I asked her if she would take a picture of my finger because my phone was broke. She took a picture of my finger and called my daughter for me. Uh, she called my daughter for me. I went back upstairs, and so my daughter didn't come. So I got the other neighbor to call my daughter a second time. So once she called the second time, my daughter arrived. And so by that time, my finger was swollen. And it was still slight, it would bleed and then it would stop bleeding. And so then I called the police. And so my daughter went downstairs to keep them in the office until the police arrived. And so once the police arrived, my daughter wanted to speak to Becca about the notice because the notice didn't make sense to her. She felt like that the notice read, she noticed that the locks had been changed on the 8th when trying to, as she say, serve legal papers. But so my daughter, quickly read the papers and went downstairs. One police came up with me. The other police went downstairs. And so the recording of the conversation between Becca and my daughter, there's a recorded conversation that was submitted in evidence. Um, my daughter never got out of hand. She never raised her voice.
Objection,
She
Your Honor.
just wanted.
Testifying to a document not admitted into evidence.
All right, well, are you talking about when your daughter never raised her voice, you said? That's not from a document, is that?
No, sir.
All right, so I'm
Your
gonna
Honor,
That's
rule for
Your Honor, may I take the witness on voir dire?
Yeah, let me finish her just a second, because you're gonna cross-examine her anyways. So let me allow her to finish.
So my daughter recorded the conversation between her and Becca, and which was submitted into evidence. My daughter never raised her voice. My daughter never voice-wise demonstrated any hostile environment in any of that. My daughter basically wanted to know, who do we contact?
Judge, I'll ask to take the witness on voir dire. I believe she's attempting to mislead the court.
And we'll get to that in just a moment. If your daughter, if you want her to testify, she can testify, and then she can tell
Okay.
me what she
I'll
experienced.
let her testify to what happened. Come up, Renee.
Well, hold on, not yet.
I'm gonna go get some tissue.
Yeah.
I'll be right back.
So Miss Wheeler, if you're done testifying, then Mr. Vasquez has an opportunity to ask you questions first.
Oh, I'm
Yeah.
sorry. Okay.
If you need to go get some water real quick, go ahead and do that.
Hi, Ms. Wheeler. Real quickly, in your cross-examination of Miss Kimberly and in your testimony, you didn't deny acting abrasive in the leasing office, did you?
I didn't act abrasive, so I had
Objection,
nothing
I'll
to deny.
withdraw the objection.
All right, if you'll just go ahead and just answer his question, ma'am.
No,
In your
because I didn't.
testimony, you did not deny that you shouted, correct?
I may have shouted being upset, because I did remember saying, "Well, I'm next." So yes, I may have shouted, "I'm next."
And you testified earlier that you were saying that in the incident with your daughter, she was never aggressive, correct?
That is correct, sir.
You weren't there for that interaction,
But I
correct?
listened to the video, sir.
Okay. Your Honor, then we'll object to testifying to a document not admitted to evidence. She's testifying to a video. She says it's admitted to evidence. We never received that video.
All right, so Ms. Wheeler, you've indicated that the video, you've submitted it to the court?
Yes, sir.
Okay, so just to let you know, is evidence, even though you've sent it to the court, is not admitted until we actually have it presented before the court. Okay, so in other words, we need to go through the process of admitting it into evidence in order to be able to rely on that. Do you understand?
Yes, ma'am. Yes, sir. But it was admitted in evidence as part 2.
No, it was not admitted into evidence because I have not admitted it into evidence.
Oh, okay.
What I just said was, just because you send it here doesn't make it admitted evidence. That just means it's here for accessibility and to ease. You still have to get it admitted. So you still have to provide the proper foundation for it, all those types of things, okay?
Okay.
Nothing further for this witness, Judge.
Okay. Give me just a second here. Okay. All right. So, Ms. Wheeler, you wanted your daughter to testify, is that correct?
Yes.
All right. So, if we can go ahead and move the camera.
Hello, Your Honor. My name is Renee Andrea Brooks.
Okay, Ms. Burks. So what I'm going to do is I'm going to give you a little bit of leeway to go ahead and give me some testimony. Now, keep in mind, we are basically out of time. So I have another hearing that's starting right now at 2 and it's 2 o'clock.
Yes, sir.
I only need you to talk about your personal knowledge, okay, with respect to, and in this case, because there's an allegation that was raised when you came into the office, okay? So you can only speak as to that, okay?
Yes, sir.
All right, you may proceed.
Upon me getting to my mom's residence, I read over the notice and I had some questions. So I know that my mom isn't allowed in the office. So I went downstairs to try to get a better understanding because as it read, it kind of didn't read right. So I came in the office and I turned my recorder on my phone to record the conversation. So I came in, the young lady that's at the front desk, she came to me, she asked me, how can I help you? I said, I need to ask Becca about
Objection, hearsay.
All right, so again, Ms. Burks, you'll need to talk about your personal knowledge only, okay?
I came to the office with the notice in hand to speak with Becca. I spoke with Becca. Becca said, it's out of our hands. You need to contact legal. Legal is listed on there. So as me looking through it, I thanked her for her time. I went back upstairs. By that time, the police had got there. The police looked over paperwork, and I noticed that Becca was listed as legal, she said. So I went back downstairs. At that time, the office was closed. So I just waited till the police came so that the police could go and ask them who is legal. Because who is listed that you say who legal is the office manager.
Okay.
I was
Anything?
never irate. I was never out of hand. I just was trying to get clarity on who do I need to contact next.
Okay. All right, Mr. Vasquez, any questions of the witness?
No, Judge.
All right. Okay. Ms. Wheeler,
Yes.
do you have any more testimony that you wish to provide or any other witnesses that you wish to call?
Well, I'd like additional testimony.
Okay, go ahead.
Like I mentioned, as a disabled person, I've never been treated fairly for the simple reason the work orders that was the biggest concern was my reasoning for going to fair housing has never been entered in by anybody. The manager, Becca, came in my house and I showed her all the things that was broke or that needed repaired.
Okay, so I'm gonna
Objection.
put you on pause a second, Ms. Wheeler. You have an opportunity to file a repair and remedy lawsuit against the apartment complex for failing to provide a unit that is habitable, okay? So that they have to make sure that it's a place that, for instance, that there's no roaches, running around, that the air conditioner works, the TV, not TV, I'm sorry, the refrigerator is working properly, okay? You can file that lawsuit. That would be filed in this court, but I will not hear testimony with respect to those issues
Oh, okay.
in this hearing because the two are completely exclusive of each other, okay?
Well, as far as the eviction, sir, I've pretty much moved out. So uh,
Have you turned in the keys?
I don't know who to turn the keys into
Well, you're
because
the
I
manager,
went
right?
I went to Becca over at the other property, and I was told she's no longer with the property. So the only person that's left is Kim at where I stay. And um, if I'm not to go in the office and I have no way to notify somebody, I don't want to just pop up and say, "Oh, I want to turn in the keys," and then that creates a problem. So I would like instructions. Who will be? Do I turn them in to Mr. Vasquez or who?
I can't give you that instruction at this point right now. I can't tell you. You can certainly contact Mr. Vasquez and you can have that discussion with him.
Okay.
Judge, if I can interject, we'll talk to our clients and we'll work out something if it's just simply turning in keys.
All right. So, Mr. Vasquez, did you wish to, because I know you had indicated before about voir dire the witness, is there anything else that you needed to do with respect to that?
No, Judge, it was with regards to the witness testifying to the video that hasn't been admitted into evidence.
Okay. All right. All right. Is there anything else then, Ms. Wheeler?
No. All I can say is I've never hurt Kim, but Kim has hurt me 2 times, my finger and my foot.
Okay. Mr. Vasquez, anything else?
No, Judge.
All right. So these cases involving lease violations are complicated to say the least. And they're complicated because it's not an issue that is super simple, such that, for instance, when you're not paying, that's black and white. Either you paid or you didn't pay, right? But with
Right.
respect to the lease violations, they're a little bit more specific, right? And so then it has to do in terms of to what level was this done? For instance, if you have a person that is an unauthorized tenant, and I believe that Mr. Vasquez, you indicated in some of your paperwork, but that was not part of the original notice to vacate. And so I'm not going to consider the fact that her daughter's living there or not living there, because that's not part of the notice to vacate that this hearing would be addressing. The issues here are the lease violations in terms of being disruptive and also the fact that Mr. Vasquez has indicated that you, Ms. Wheeler, caused harm to Ms. Duque. What's difficult for me is Ms. Duque, as I told you, Mr. Vasquez did not provide any testimony. She just answered yes or no to every one of your questions. So I don't know to what extent her nail was torn off. I don't know if it was completely torn off. I don't know what kind of injury she sustained of it. I don't know the specifics on how the toenail was torn off. I don't know if it's because it got caught in the door and it got caught on the something, and then that's what happened. I don't know the circumstances to what extent these things occurred. There are some violations that you've indicated that you've raised in terms of these discussions, the lock changes, right? I did not get any type of testimony from Ms. Duque that they in fact went in, confirmed that the locks were changed, and they had to go back and change them back. So again, Ms. Wheeler says she never changed the locks. And all I have is a statement that the locks were changed and a statement from Ms. Wheeler that they were not changed, right? So I don't know to what extent any follow-up that went on to prevent Ms. Duque to be able to go into the property to either post a notice or for what was going on there, okay? With these kinds of cases, there are limited type defenses. For instance, retaliation is a defense. It's one of the rare ones in this kind of case. Now, for Ms. Wheeler, you indicating that you feel that you've been discriminated against and that's why you're claiming the retaliation. but I certainly didn't have enough information with respect to that discrimination, other than you indicating that she went ahead and took in a Caucasian couple, that she spoke to them even though you had been waiting there longer. And that's just simply not enough evidence to suggest that you were retaliated against, and that's why they're evicting you. There also is in the law an opportunity to cure any type of lease violation. So question is, how do you cure if a person is being disruptive or if they're being physical in a way, right? So the very first complaint that came in was approximately a year ago. That's when the police came and indicated that there was a criminal trespass notice. Yes, Mr. Vasquez, you do indicate that there was evidence that was submitted, but the same thing that I spoke to Ms. Wheeler, we didn't go into any of the foundational issues with respect to that. That is a police report, and that is not necessarily a criminal trespass notice. And so that is done differently. She's indicated she never received any actual documentation. Again, absent anything, that is in conflict with that, then that means she didn't receive it, but we don't have any documentation here show that she in fact was given a criminal trespass notice, other than that there's a police report, and a police report doesn't equate to that. I can understand her confusion in not going in to take in the keys, but ultimately, Ms. Wheeler, you have not forfeited the property until you turn in those keys.
Okay.
You've already indicated, and Mr. Vasquez has already indicated that he's going to talk to you about that. You all can do that separately.
Okay.
The concern for me here is that after that initial notice of that, the disruption, I'm going to call it, back last year,
Mm-hmm.
it then went, I don't know, I'm estimate, what, 10 months or so before that there was an issue that came up. I'm not looking at that second allegation of disruption as a continuing type violation under the circumstances. I'm not convinced under these circumstances that these violations are so egregious enough at this stage that I'm going to order an eviction. However, Ms. Wheeler, you've already indicated that you've either already moved out or you're planning on moving out.
I'm 95%. I stayed. I worked this weekend. Well, I worked this weekend, but I moved. I just have just just one room, and it's just boxes.
Well,
If I can just,
this,
by me being sick, if I can just get over there to get those boxes moved, I'll be more than happy to turn in the keys.
I'm not granting you any time to do that, right? Because that's not within my authority to do so.
Okay.
But I'm just telling you that while I'm going to deny the eviction at this time, there are issues here, obviously, and that does not mean that this is not going to go forward under other circumstances. Okay.
Okay.
You have not vacated the property until you've turned in those keys. It's as simple as that. So
Okay.
however type of arrangements you need to make, they need to be
I
done.
will.
And
I
my
will. I'll
suggestion
make
would
them with
be to do
Mr.
those quickly.
Vasquez.
All right. That'll be
How
the
do I
order.
contact him?
Excuse me?
Judge,
Sir.
or Miss Wheeler, you should have received, I don't know if you received emails from Miss Sonica Reddy, our other attorney at our firm. If you
We
haven't,
called her office, but it was no response. She
okay.
never. We went 5 times to corporate trying to obtain information for her, and finally we got a letter, and so we called her, that number that was on the letter that represented her, and we left messages. These were written messages.
So let's do this. I have the next case that's we're 15 minutes behind. If you can share phone numbers, or Mr. Vasquez, if you have your number, you can give her a
Renee,
call.
bring me a pencil. Okay.
Here, Miss Wheeler, do you have a good email address?
I don't get emails because I have low vision.
Okay. Does your daughter have an email address that we can use?
Yeah. Hers is F as in Frank, R as in rabbit, E as in elephant, N as in no, A as in apple, B as in boy, R as in rabbit, O as in open, O as in open, K as in kite, S as in Sam, at yahoo.com.
All right. We'll send her an email. It'll come from our office, so it'll be my first name, Stephen, at Warren Callion. So you guys
Okay.
should be on the lookout for that, and then we can coordinate turning in keys.
Okay. Thank you, Mr. Vasquez.
Thank you all very much and good luck to you.
Thank you, Judge.
Thank you.
Bye-bye.
Goodbye.
We're doing the next hearing in person, right? Okay.
Well, no, right now, it's in person.
Yeah.
The two-thirds, we have nationwide hearing.
Look like they saw through her shit. What you say? She had to be coerced.